Question 62 of Secunda Secundae has to do with restitution. Now, restitution just means that when something is taken from somebody, should it be repaid? And I think it's kind of commonsensical, and it's actually kind of interesting because Thomas asks a lot of questions about this in this question, a lot of articles, I should say. And a lot of it is pretty commonsensical, but there are a few kind of fine-tuning items that I think are pretty interesting, especially what kind of justice this falls under. And so in the first of these articles, Thomas says whether or not restitution is an act of commutative justice. And if you remember from the previous question where we made the distinction between commutative justice, which is between one man and another, and then also distributive justice, which has to do with the whole community or maybe a government handing out goods to individuals, like maybe a welfare program or something like that. And Thomas says, yeah, restitution primarily has to do with one person to another. So if you steal $10 from somebody, well, you need to give that $10 back, and that would fall under commutative justice more than it would fall under distributive justice. Article 2, whether restitution of what has been taken away is necessary for salvation, and he says, yeah, it is, because anytime there is injustice, it has to do with a crime basically against a person, and Thomas is very consistent in saying that if some kind of injustice is done against a person, well, that does bear on our eternal salvation. And so, yes, it is necessary for salvation that one bring back the order of justice, the order of equality in this circumstance. Article 3, whether it suffices to restore the exact amount taken. And a lot of these, he gives a lot of examples and he fine tunes it a little bit, but basically it comes down that, yeah, of course, if you take $10, then you need to repay $10 in return, and that would be in line with commutative justice. Article 4, whether a man is bound to restore what he has not taken. And this is kind of interesting because you're like, what does that mean? How would I restore something that, I didn't take? And he says, a man is bound to make restitution according to the loss he has brought upon another. Now, a man suffers a loss in two ways. First, by being deprived of what he actually has, and a loss of this kind is always to be made in repayment of the equivalent. Again, the example I used of you steal $10, you pay back $10. But then he gives an example. He says, for instance, if a man damnifies another by destroying his house, he is bound to pay him the value of the house. Okay, that kind of makes sense. Secondly, a man may damnify another by preventing him from obtaining what he was on the way to obtain. A loss of this kind need not be made good and equivalent, because to have a thing virtually is less than to have it actually. And so if a person was on his way to getting something and you prevent him from getting it one way or the other, well, there has to be some kind of equality, some kind of repayment, but how can you pay back something that the person doesn't have? They never got it in the first place. But Thomas says, however, he is bound to make some compensation according to the condition of persons and things. And I think a lot of these, you really have to look at the circumstances, and that's why we have judicial laws and judges that look at cases in particular and make judgments according to the particular circumstances and conditions of the offense. Article 5, whether restitution must always be made to the person from whom a thing has been taken, and as you might expect, Thomas would say yes to this as well. Article 6, whether he that has taken a thing is always bound to restitution. Whether he that has taken a thing is always bound to restitution. He says, with regard to a man who has taken another's property, 2 points must be considered: the thing taken and the taking. By reason of the thing taken, he is bound to restore it as long as he has it in his possession, since the thing that he has in addition to what is his should be taken away from him and given to him who lacks it according to the form of commutative justice. Now, in this case, it's a pretty long corpus, and Thomas gives a lot of examples. And for the sake of time, I won't go into all of the particulars, but if you're interested in this, go ahead and go back and read this. But again, I think, to go into all the particulars of this particular article probably is not worth our time. And then in Article 7, he says whether restitution is binding on those who have not taken. Now, this is kind of interesting. It's like, what does this mean? Is it binding on those who have not taken? And he says a person is bound to restitution not only on account of someone else's property which he has taken, but also on account of the injurious taking. Hence, whoever is cause of an unjust taking is bound to restitution. Now, he gives some examples, and I'll just go to the end of this corpus. He says, in some of the cases mentioned above, a man is not always bound to restitution because counsel and flattery are not always the efficacious cause of robbery. So what he means by this is maybe you encouraged somebody else to take somebody else's goods, or maybe you flattered a person that, what a great robber he is, or you encouraged him in some way, but you didn't actually do the theft yourself. Well, there is some responsibility that you have because you contributed to the inequality and the injustice that was done. He said the counselor or flatterer is bound to restitution only when it may be judged with probability that the unjust taking resulted from such causes. So again, this, you really have to look at the circumstances and say, well, how much responsibility do I have for that guy stealing something, even though I didn't steal it myself, but I encouraged him, or I flattered him, or in some way I was indirectly responsible for this, and there has to be some kind of restitution. But since you didn't take the money, how do you repay what you don't have because it's in somebody else's possession? And then finally in Article 8, it says whether a man is bound to immediate restitution or may he put it off. Okay, can you delay giving it back? And he says, even as it is a sin against justice to take another's property, so also is it to withhold it, since to withhold the property of another against the owner's will is to deprive him of the use of what belongs to him, and this causes an injury to him. Consequently, one is bound to immediate restitution if possible, or to ask for a respite from the person who is empowered to grant the use of the thing. Okay, so like I said, most of this is kind of common sense, but I think the best thing to take away from these 8 articles of question number 62 is that restitution, it falls under commutative justice, which is between one man and another, and not so much distributive justice, which we'll talk about in the next question, which will have to do with the sins that are opposed to distributive justice when you are handing things out as a community to individuals. All right, thank you for joining me as we travel through the Summa Theologia, one question at a time. God bless you.